Breaking update. Stay with me because this is one of those moments in American history that future law students will study line by line. Stay tuned by subscribing and liking the channel to get videos like this. Early this morning, while most of the country was asleep, something extraordinary happened inside the federal courts of Washington, D.C. At precisely dawn, a three-judge panel issued a ruling that didn't just affect Donald Trump. It reshaped the legal limits of presidential power itself. Before we go any further, if this is your first time here, hit subscribe and turn on notifications. The next few days are going to move fast, and you don't want to be catching up after the fact. Here's what unfolded. Just before 7 a.m. Eastern Time, the D.C. Circuit Court of Appeals issued a decision that left no room for interpretation. Donald Trump's emergency request wasn't delayed. It wasn't debated. It wasn't even scheduled for argument. It was rejected outright, and not by a divided court. All three judges agreed. No dissent, no hesitation. A unanimous ruling. Trump's legal team filed their request late last night, hoping to freeze the case. Within hours, the court responded with a single word that changed everything. No. In legal terms, this was a per curiam decision. That means the court spoke with one voice, and the language they used was devastating. The judges wrote that Trump's alleged efforts to remain in power after losing the 2020 election were unprecedented in our nation's history. Courts do not use that word lightly. When they do, they are signaling that this isn't a gray area. This isn't a close constitutional question. This is conduct that falls far outside the protections ever intended for a president. The ruling delivered four crushing conclusions. First, the court rejected absolute presidential immunity entirely. Second, it ruled that Trump's actions were personal and political, not official presidential duties. Third, it confirmed that the criminal charges against him can proceed. And fourth, it established a legal framework that now applies to every remaining criminal case Trump faces. This is why today matters more than most headlines are admitting. In past presidential scandals, accountability always stopped short of criminal trial. Nixon was pardoned. Reagan's aides absorbed the fallout. Clinton faced impeachment, but no prosecution. What's happening now has no modern precedent. For the first time, a former president is moving forward toward trial in multiple criminal cases, while his core immunity defense collapses in real time. Trump's team believed their last firewall was the Supreme Court, 6 conservative justices, 3 appointed by Trump himself, a chief justice known for protecting the court's image. Surely they thought someone would intervene. So far, silence. No emergency order, no shadow docket maneuver, no signal that the court sees this as urgent. Even Republican allies are saying the quiet part out loud. Senator Lindsey Graham acknowledged publicly that without Supreme Court intervention, the country could see a criminally convicted nominee in a presidential election year. That statement alone tells you how serious this moment has become. Now the clock is ticking. Judge Tanya Chutkan has already invoked the Speedy Trial Act. Once the immunity issue becomes final, the law requires the case to move quickly. That countdown began this morning. If the Supreme Court stays out, the original trial date snaps back into place. No delays, no escape hatches, and unanimous appellate rulings like this one are rarely overturned. Inside Trump's legal operation, the reality is sinking in. Prosecutors have witness lists filled with people from Trump's own inner circle. His vice president, his chief of staff, his White House counsel, people who were in the room, people with first-hand knowledge. The evidence isn't theoretical. It's messages, emails, recordings, and video the world has already seen. Trump's response has been familiar. All caps posts, attacks on judges, claims of persecution. But one post crossed a dangerous line, warning of chaos if prosecutions continue. Law enforcement isn't brushing that off. Every statement is being documented. Every post becomes potential evidence. Security across Washington has quietly escalated. Federal buildings reinforced. Threat assessments raised. Agencies coordinating behind the scenes. Officials remember January 6th. They are not assuming rhetoric stays rhetorical. And this isn't just one case. Washington is one front. Georgia is another, with state charges immune to federal defenses. Florida is waiting with classified documents and potential obstruction counts. New York remains active. Multiple jurisdictions, independent evidence, Parallel timelines. This convergence is unprecedented. Beyond Trump himself, the political impact is already visible. Republican strategists are watching polls that show conviction would fracture the base. Swing state candidates are distancing themselves. Silence is replacing loyalty. And looming over everything is the unresolved question of disqualification under the 14th Amendment. Courts are already grappling with it. The Supreme Court will have to answer. Globally, allies are watching closely. Adversaries too. Domestic instability in the United States doesn't stay domestic. But at its core, this moment is about something larger than one man. For decades, the assumption was that presidents existed beyond criminal accountability. That assumption has now been shattered, not by speeches, not by politics, by procedure, court orders, timelines, evidence, witnesses under oath. The process doesn't negotiate. It doesn't slow down for campaigns, and it doesn't care about rallies or slogans. The next several weeks will determine whether accountability has real meaning in American democracy. If you want analysis that goes beyond sanitized headlines, subscribe now. We'll follow the documents, the rulings, and the strategy as it unfolds. Drop your prediction below. Does conviction come before the election, or does delay win again? I'll see you in the next breakdown.